And Mr. Manning, we're able to hear what the prosecutor just had to say regarding what she believes your intentions are here this morning.
Yes, Your Honor.
She indicated to the court she believes that your desire to waive your right to have this case presented to a grand jury, and I'll explain in a moment in more detail what that actually means. And then you're going to go ahead and plead guilty to the charge and the information, which I will also review with you to make sure you understand that. If I accept your plea, we would then continue the sentencing to a future day to get some evaluations completed, come back on a future day for sentencing, where there is no agreement at this time between the parties regarding any recommendations for sentencing. Each side is free to recommend to the court whatever sentence they believe would be the right and fair thing to do. Is that your understanding of the discussions that took place between your lawyer and the prosecutor, and most importantly, what you want to do today?
Yes, Your Honor.
Well, before I can accept your plea, I need to make sure you understand everything going on here. I need to make sure you understand what it is you're charged with and pleading guilty to, the rights you have that you give up by pleading guilty, as well as all the possible penalties you face. So for me to determine those issues, I'm going to ask you a series of questions. Now, if at any point when I'm asking you these questions, if you're unsure or unclear of anything I'm asking you, if you need anything repeated or clarified, if you want a moment to speak with your lawyer to ask him questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything we're doing here, all right?
Yes, Your Honor.
All right. Let's get started then. How old are you, sir?
36.
Are you able to read and write the English language?
Yes, Your Honor.
Do you have any difficulty with that, or difficulty understanding what you read in the English language?
No.
Are you a U.S. citizen?
Yes, Your Honor.
Now, before you came into court here this morning, have you any drugs or alcohol of any
No,
kind?
Your Honor.
What about within the last 48 hours?
No, Your Honor.
Not even prescribed medication, nothing?
No, Your Honor. Nothing.
Now, did you receive a copy of the information that was filed in this case? That's the document that sets forth the specific charge you're accused of committing?
Yes, Your Honor.
And you had a chance at some point to review that, I'm assuming?
Yes.
Now, in that information, you are charged with one count. And what is alleged here and what you'll be admitting to is on or about October 26, 2024 in Willoughby Lake County, Ohio, that you did by force, stealth, or deception trespass in an occupied structure or in a separately secured or separately occupied portion of an occupied structure, specifically the residence located at 38751 Lakeshore Boulevard, apartment 323 in the city of Willoughby. And you did that with the purpose to commit in the structure a criminal offense, that being theft. That conduct constitutes the offense of burglary. It's a felony of the 3rd degree. Do you understand what you're charged with and pleading guilty to in regards to this chart in count 1 here?
Yes, Your Honor.
Any questions about it for me?
No, Your Honor.
Well, then before I can accept your plea, I need to make sure you understand all the rights you are giving up. And you first of all have a right to have this case presented to a grand jury. Now, the charge I just read to you is what we call an information. An information is a criminal charge brought by the prosecutor's office without the case having previously been reviewed or considered by a grand jury. Now, what a grand jury is, it's made up of a group of citizens here from Lake County that get together and they meet privately, in secret, for the purpose of evaluating evidence in cases to determine whether probable cause exists that someone committed a crime. Probable cause is defined as some evidence that would suggest a person probably committed a criminal offense. Everyone in the state of Ohio accused of a felony has the right to have a grand jury independently review the evidence in case and make a decision without the government being involved in that decision, whether someone should be charged or not. And you have that right as well. But you can give up that right if you desire and go forward in the charge brought by the prosecutor in the information. And your attorney has indicated he believes that's what you want to do. Is that correct?
Yes, Your Honor.
Well, before I can go any further, I need to have you acknowledge that here in open court in writing. And I have in my possession at this time a one-page document called a waiver of indictment, which sets forth and explains everything I've just explained to you about this grand jury process and indicates that you want to give up that right. I need to make sure you understand this document and you sign it here in open court, again, before I can continue. Now, my understanding is before I came out here, you had a chance to review that document with your lawyer. Is that correct?
Yes, Your Honor.
Mr. Bancik, is that accurate? Did you review this with your client and read it over with him, answer his questions?
Yes, Your Honor.
Did he indicate an understanding of it to you when you did that?
Yes, Your Honor.
Is that correct, Mr. Manning?
Yes, Your
You
Honor.
understand what the document says?
Yes, Your Honor.
Any questions for me about it?
No questions.
Now, it also appears you signed the document. Did you, in fact, sign it?
Yes, Your Honor.
Mr. Manning, did you witness that?
Yes,
I'm sorry,
Your Honor.
Mr. Bancik. Did you witness that?
Yes, Your Honor.
Ms. Tuttle, you as well?
I did, Your Honor.
All right, well, I'll make that document part of the record. At this point, I'm going to review with you, Mr. Manning, all the other rights you have that you are giving up by pleading guilty. And you first of all have the right to have a trial in this case. And that trial could be to me as a judge, or I listen to all the evidence and I make that ultimate decision whether you're guilty or not guilty. But you also have a constitutional right to have a jury trial. A jury trial would be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. The jurors would consider and weigh all that evidence, and then those jurors would make that ultimate decision. And that ultimate decision reached by the jurors would have to be a unanimous decision, which means all 12 jurors would have to agree together, one way or the other, whether you were guilty or not guilty of this charge. You understand that?
Yes, Your Honor.
You understand by pleading guilty, you're giving up your right to have a trial in this case?
Yes, Your Honor.
Now, if we had a trial, the prosecutor here would be representing the state of Ohio, and she would have what we call the burden of proof. With her having the burden of proof, what that means is that it's her job, or she bears the responsibility or the obligation of proving you guilty before you could ever be found guilty. Do you understand that?
Yes, Your Honor.
You are presumed innocent of this charge, and that presumption of innocence will stick with you and remain with you until the state, if at all, is ever able at a trial to overcome the presumption and prove you guilty. Do you understand that?
Yes, Your Honor.
Now, I speak of this burden of proof. Since it's a criminal case, the burden is what we refer to as proof beyond a reasonable doubt. And that is the highest burden we have in our justice system. What it actually means, it's the amount of the evidence and the quality of the evidence the state would have to present at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or each part of the charge beyond any reasonable doubt before you could ever be found guilty of this charge. You understand that?
Yes, Your Honor.
Now, if we did go to trial, you would have the right to have an attorney represent you at that trial. If you could not afford an attorney to represent you at trial, the court would appoint one for you free of charge to do that. Do you understand that?
Yes, Your Honor.
Now, also, if we did go to trial, and I talked about the state having to prove you guilty beyond a reasonable doubt, in order to try to do that, the state would bring witnesses into the courtroom to testify for the state by answering questions from the prosecutor. Once those witnesses answered the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same person's questions, and we call that cross-examination. So he could ask him anything he wanted to, within certain rules. Do you understand that?
Yes, Your Honor.
Further, hang on a second. Do you understand by pleading guilty, you're giving up your right to cross-examine or confront these witnesses that would come in here and testify against you?
Yes, Your Honor.
Now, you'd also have the right at a trial. You can call your own witnesses to come to court to testify for you if you wanted to, and to answer your lawyer's questions. Now, you don't have to do that. You're not required to do that, but you have the right to do that if you want to. Do you understand that?
Yes, Your Honor.
And you further can request this court issue an order, and that order we call a subpoena. And what a subpoena would actually do is it would force or make someone come to court to testify for you and answer your lawyer's questions if that person wasn't willing to come in voluntarily on their own. Do you understand that?
Yes, Your Honor.
Do you realize you're giving up that right?
Yes, Your Honor.
You'd also have a right at a trial. You could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you don't want to. That is a decision or a choice that you would have to make. Do you understand that?
Yes, Your Honor.
And since that's solely your choice, what that really means then is that nobody else could force you or make you. Nobody could compel you to testify against yourself at a trial if you didn't want to. I can't make you testify. But most importantly, the prosecutor here, she's not allowed to call you as a witness, force you to get up on the stand and answer questions and testify. Your own lawyer can't make you testify if you didn't want to. Do you understand that?
Yes, Your Honor.
Further understand that if we did go to trial and you were found guilty, you would have the right to appeal or challenge that guilty finding to a higher court, a court that sits above me and reviews my decisions. By pleading guilty here today, you are giving up or waiving any right you have to appeal a guilty finding. This court will enter if your plea is accepted, as well as any other issues you could have raised or brought to my attention up to this time. Do you understand that?
Yes, Your Honor.
All right, well, any questions at all about these rights we've just discussed? These are all the rights you have and all the rights you've given up by pleading guilty. Any questions?
No, Your Honor.
Do you understand them all?
Yes, I do.
Do you still want to plead guilty?
Yes, I do, Your Honor.
Do you understand that your guilty plea, any guilty plea, quite frankly, is a complete admission of guilt? It means you're admitting to the facts being alleged by the prosecutor, and we're not going to argue at any later time or sentencing that you didn't do it or it's someone else's fault or anything like that. Do you understand that?
Yes, Your Honor.
Further, as a result of pleading guilty, the effect of that plea is that you will be found guilty by the court, and then you will subsequently, on a future day, be sentenced by the court. Do you understand that?
Yes, Your Honor.
Now, as far as possible sentencing goes, you're pleading guilty to a felony of the third degree. This offense is punishable by a possible term in prison of a minimum of 9 months, a maximum of 36 months, or certain increments in between of either 12, 18, 24, 30. So if I determine that a prison sentence is warranted, I'd select one of those numbers, 9, 12, 18, 24, 30, or 36, and that'd be the number of months in prison you'd have to serve. Do you understand that?
Yes, Your Honor.
Now, are you currently on probation or parole to any other courts or agencies?
No, Your Honor.
Do you have any other criminal charges pending against you anywhere?
No, Your Honor.
If a prison sentence is imposed in this case upon your release from prison, you could be placed on what we call post-release control. It's sometimes referred to as parole. It's a period of supervision you would be on after you serve the prison sentence. And in this particular case, it could be up to 2 years. Do you understand that?
Yes, Your Honor.
And if you were on post-release control and you were violated any of the conditions of your supervision, the parole authority could return you to prison as punishment for violating their rules for another 9 months for each separate violation you commit, up to an overall maximum of 50% or half of whatever the prison term was imposed by the court. Do you understand that?
Yes, Your Honor.
Your Honor, I believe the post-release control is a mandatory 1 to 3 years. It's an F3 burglary.
Oh, you're right. Thank you.
Sorry.
No, don't be sorry. I'm glad you did that. That is an offense of violence. I was wrong about that, Mr. Manning. The offense you're pleading guilty to is considered to be an offense of violence. Since it's an offense of violence, post-release control is actually mandatory if you go to prison. Prison's not mandatory. But if you were sent to prison, then upon your release, you would be placed on post-release control for a minimum of 1 year up to a maximum of 3 years. You understand that?
Yes, Your Honor.
Thank you, Ms. Tuttle. Same thing applies though. If you do find yourself on post-release control, you're violating the conditions, the parole authority can return you to prison as punishment for violating their rules for another 9 months for each separate violation you commit, up to an overall maximum of 50% or half of the prison term I just imposed. You understand that?
Yes, Your Honor.
Now, aside from the possible prison sentence I just mentioned, there's other sanctions that could be ordered. You could be fined up to $10,000. You could be ordered to pay court costs. You could also be ordered to reimburse the county for any cost of confinement, community supervision, or treatment, if any of that were applicable. Do you understand that?
Yes, Your Honor.
You could also be ordered to pay restitution to any victim for any economic loss any victim may have suffered as a result of the conduct involved. Do you understand that?
Yes, Your Honor.
Now, a few moments ago, I explained the possible prison sentence. Again, I did use the word possible because, as I said, prison is not mandatory. In this case, you are eligible for probation, or what we refer to as community control sanctions. Do you understand that?
Yes, Your Honor.
Now, just because you're eligible doesn't mean you'll automatically be put on community control. It means I will consider that if that's what you're going to be asking for. I'm going to look at all the information presented to the court. Then I'll make the decision that ultimately I think is the right thing to do. You understand that?
Yes, Your Honor.
Now, if you are put on probation, it could be for up to 5 years. And as the judge, I have the discretion to order a wide variety of rules and conditions for you to follow. One of the conditions could be an order that you serve a term in the Lake County Jail of up to 6 months as a condition of probation. You understand that?
Yes, Your Honor.
So even if you get probation, that doesn't necessarily mean you walk out the door. There could be local incarceration in the county jail, which is different from prison. But there could be local incarceration as a condition of probation. You understand that?
Yes, Your Honor.
Again, that's not mandatory either, but I need to make sure you understand that. That's a possibility as a condition of probation. You understand that?
Yes, Your Honor.
And if you are on probation at any point and you ever find ever violate any of the conditions or rules of your probation, we would have a hearing to see if you're what's called a probation violator. If it was determined that you were, I could extend your probation up to 5 years. I could impose more restrictive sanctions against you, including local jail time, or I could terminate or end your probation at that point and send you to prison then. And if I did it at that point, again, it could be 9, 12, 18, 24, 30, or 36 months. Do you understand that?
Yes, Your Honor.
Lastly, when we do come back here for sentencing, you'll have the right at that time to say anything you want. Anything you'd like me to know or consider. Your lawyer could speak on your behalf. He can recommend the sentence to the court. The prosecutor is also allowed to recommend the sentence to the court. Do you understand that?
Yes, Your Honor.
Do you understand that whatever anyone says at sentencing regarding what they think the sentence should be, it is just what I said. It's a recommendation. I don't have to follow that if I didn't think that was the right thing to do. Do you understand that?
Yes, Your Honor.
All right, well, any questions at all about the potential penalties you face by pleading guilty here?
No, Your Honor.
You understand all the possible consequences?
Yes, Your Honor.
And do you still want to plead guilty?
Yes, Your Honor.
Have you had enough time to talk about this case with your lawyer and have him go over everything with you and answer your questions?
Yes, Your Honor.
Are you satisfied with the advice and counsel of your lawyer?
Yes, Your Honor.
Has he, or has anyone for that matter, made any promises to you about what's going to happen at sentencing, which is inducing you to plead guilty?
No, Your Honor.
Have you been threatened or coerced in any way to plead guilty?
No, Your Honor.
Are you entering the plea freely and voluntarily?
Yes, Your Honor.
All right then, Mr. Manning, any questions for me at this point regarding anything we've just talked about, the rights you're giving up, penalties you face, what you're pleading guilty to? Any questions at all?
No, Your Honor.
Do you need any more time to speak with your lawyer before we go forward with your actual plea of guilty?
No, Your Honor.
All right, then what's going to happen at this point, the prosecutor here, she's going to explain for me what she believes the evidence would establish at a trial if we did have a trial. I want you to listen to her because now I have some follow-up questions for you, all right?
Okay, Your Honor.
Ms. Tuttle.
Thank you, Your Honor. At 2:13 a.m. on October 26, 2024, in Willoughby, Lake County, Ohio, the defendant Daniel Manning, along with another individual, Mike Tate, entered the apartment of Julie Thies, located at 38751.
Thies, T-H-E-I-S-S?
Yes. Located at 38751 Lakeshore Boulevard, apartment 323. They were wearing sweatshirts with the hoods pulled up, and Mr. Tate was wearing latex gloves. The men exited the apartment at 2:16 a.m. carrying a cash box that they had stolen from Miss Thies' bedroom. At the time of the entry, Miss Thies was not present, but her 14-year-old daughter was sleeping in the apartment. When police spoke to Mr. Manning about the incident, he admitted that he entered the apartment without permission and left with that cash box, believing there to be drugs inside. Thank you.
So is actually someone was present?
Yes, Your Honor.
So it should be an F2, right?
Yes, there was some substantial negotiation prior to the information being filed.
Was the other Mr. Tate charged also?
I believe there's a probable cause warrant issued at the municipal court for him.
Thank you. Mr. Manning, were you able to hear what the prosecutor had to say regarding what she believes the evidence would show if we had a trial?
Yes, Your Honor.
What, if anything, do you have to say about those facts as she presented them? Are they true? Did you do what she said?
Yes, Your Honor.
Very well, then regarding count 1, charging with burglary, a felony of the 3rd degree, what is your plea at this time?
Guilty.
All right, I have in my possession at this time a 4-page document called a written plea of guilty and judgment entry, which explains everything I just reviewed with you. Before I can accept your plea, I need to make sure you understand what's in this document that you signed it here in open court. Hang on one second. Now, my understanding is before I came out here, you had a chance to go over this document with your lawyer. Is that correct?
Yes, Your Honor.
Mr. Vancic, is that accurate? Did you review this with Mr. Manning and go over it with him, answer his questions?
Yes, Your Honor.
Did he indicate an understanding of it to you when you did that?
Yes, Your Honor.
Is that correct, Mr. Manning?
Yes, Your Honor.
You understand what that document says?
Yes, Your Honor.
Do you have any questions for me about anything set forth in that document?
No, Your Honor.
It also appears that you signed the document. Did you sign it?
Yes, Your Honor.
Did you witness that, Mr. Manning? I
Urbanski.
did that again. I'm sorry. I apologize. Did you witness
Yes,
that?
Your Honor.
I'm sorry about that. Ms. Tuttle, you as well?
I did, Your Honor.
Very well, then. At this time, the court will accept the defendant's oral and written plea of guilty. Let the record reflect the defendant was here in open court with his lawyer. He was advised of all his constitutional rights and made a knowing, intelligent, and voluntary waiver of all those rights. Court also finds the defendant understands the nature of the charge, the effect of the guilty plea, as well as the maximum penalty that can be imposed. Finding all this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea. Find the defendant guilty of count 1, burglary, a felony of the 3rd degree in violation of 2911.12A3. I will defer sentencing, order a pre-sentence report and investigation, victim impact statement. Is it issue with drugs or alcohol, I'm assuming we need to explore, is that correct? Mr.
Yes.
Okay. I'll order drug and alcohol evaluation as well. Continue bond at 10,000 cash surety, 10% with an order they have no contact with the victim or the property there. So what's going to happen at this point, Mr. Manning, is that as far as bond goes, I'm continuing your bond. There's nothing more you need to do in that regard except to continue complying with the conditions of your bond. One of those conditions also is that you do not use any drugs while you're on bond. You'll have to submit urine screens if requested. If that happens, those urine screens must come back negative. If they come back positive for anything, your bond would be revoked and a warrant would be issued for your arrest. Do you understand that?
Yes, Your Honor.
Now, the whole point of these of this pre-sentence report, drug and alcohol evaluation, is so I can get more information about you and learn more about you before sentencing. The way the probation department gets that information that they need is they're going to conduct some interviews with you. They'll administer some tests. It's important that when you meet with them and you speak with them, that you're open and honest with them, because they're going to check and verify everything you're telling them. And if they learn you're misleading them in any way, they're going to let me know that, and I would obviously consider that at sentencing. You understand that?
Yes, Your Honor.
Also, in order for me to be able to even consider probation as an option, that pre-sentence report has to be completed. And in order for that report to be completed, the interview with you must take place. So it's important you show up on time, on schedule at the probation department, so that they can conduct the interviews with you. So, because if you don't do that, they can't do the report. Without a report, the law doesn't even allow me to consider probation as an option. You understand that?
Yes, Your Honor.
So you're going to leave here right now. You're going to go over to the probation department. Do you know where that is?
Yes, Your Honor.
Okay. 3rd floor over in the jail. On the other side, though, not the jail side.
Okay.
Make sure you go there when you leave here right now. You'll fill out some initial paperwork and get the dates to come back for your interview. So make sure you do that.
Yes, Your Honor.
All right. Mr. Tuttle, anything else at this point?
No, Your Honor, thank you.
Mr. Urbancic?
Nothing further, Your Honor.
Got it right that time. All right, thank you.
All right.
Are any recommendations for sentencing which are part of the plea?
Your Honor, I am covering for another prosecutor, but I am not aware of any conversations to that nature. And my understanding is that we were just requesting the PSR and no conversations as to sentencing have been had.
Who are you covering for?
Miss Bell,
Where is she today?
she's very ill.
Oh, okay. And she's not in another court.
No.
Ms. Robertson, good morning. Does that sound accurate, the state's recitation of the discussions you had with Ms. Bell?
It is accurate, yes.
And Mr. Powell, you were able to hear what was said by the prosecutor here?
Yes, Your Honor.
She indicated to the court she believes that your desire to withdraw your previously entered plea of not guilty and enter a plea of guilty to count 2 of this indictment with the forfeiture specification. Counts 1 and 3 would be dismissed. We would then defer sentencing to a later day to get some reports completed, come back on a future day where there's no agreement between the parties regarding any recommendations for sentencing. Each side is free to recommend to the court whatever sentence they think would be the right thing to do. Is that your understanding?
Yes, Your Honor.
You know, you can be seated at this time. This takes a while. I don't interpret that as any disrespect. It's much easier to be sitting down when you're doing this. So, but you, that's what you want to do?
Yes, Your Honor.
Well, before I can accept your plea, I need to make sure you understand everything going on here. I need to make sure you understand what you're charged with in pleading guilty to, the rights you have that you give up by pleading guilty, as well as all the possible penalties you face. So for me to determine those issues, I will ask you a series of questions. If at any point when I'm asking you these questions, if you're unsure, unclear of anything I'm asking you, if you need anything repeated or clarified, if you want a moment to speak with your lawyer to ask her questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything going on, all right?
Yes, Your Honor.
All right. Let's get started then. How old are you, sir?
25.
Are you able to read and write the English language?
Yes.
Do you have any difficulty with that or difficulty understanding what you read in the English language?
No, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Now, before you came into court here this morning, have you any drugs or alcohol of any kind?
No, Your Honor.
What about within the last 48 hours?
No, Your Honor.
Not even prescribed medication, nothing?
No. No, Your Honor.
Now, you should have received a copy of this indictment. You probably got it sometime in the middle of December of last year. Do you remember getting that document that sets forth the charges that you're accused of committing?
Yes, Your Honor.
And at some point, did you have the chance to look that over?
Yes, Your Honor.
Now, in that indictment, you are charged with 3 counts. You're pleading guilty to one of those counts. The charge you're pleading guilty to is count 2, and what's alleged here and what you'll be admitting to is on or about September 2nd, 2024 in Lake County, Ohio, that you did knowingly transport or have a loaded firearm in a motor vehicle in such a manner that the firearm was accessible to the operator or a passenger without having to leave the vehicle. Excuse me. It's further alleged that you are not a qualifying adult as defined in our revised code, which makes the offense improperly handling firearms in a motor vehicle a felony of the 4th degree. Do you understand what you're charged with and pleading guilty to in regards to this count?
Yes, Your Honor.
Any questions for me about that?
No, Your Honor.
Now, the charge also carries with it what we call a forfeiture specification and alleges during the commission of the offense you had in your possession a Glock 43X pistol, along with some ammunition, a magazine, that were used as instrumentalities. Instrumentalities is some type of property that's used to commit an offense. The whole point of the specification, it doesn't increase any possible penalty or sentence that you could get, but you would forfeit any right you have, any ownership interest you have in that property to the state of Ohio. You understand that?
I understand, Your Honor.
So do you have any questions at all about what you're pleading guilty to here in count 2?
No, Your Honor.
Now, there are 2 other counts of this indictment. Those are being dismissed pursuant to the agreement. Is that your understanding?
Yes, Your
Any
Honor.
questions about those charges?
No, Your Honor.
You don't need to lean forward there if you want to,
I
but
was
it's
just trying
picking
to
you
make
up
sure
all
you
right.
can hear me.
You're good.
I'm sorry.
Okay. Well, before I can accept your plea on the count 2, I need to make sure you understand the right you are giving up, and you first of all have a right to a trial. Now, that trial could be to me as a judge, where I would listen to all the evidence and I'd make that ultimate decision whether you're guilty or not guilty of each charge. But you also have a constitutional right to have a jury trial. A jury trial would be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. The jurors would consider and weigh all that evidence, and then those 12 jurors would make that ultimate decision. And that ultimate decision reached by those jurors would have to be a unanimous decision. What that means is all 12 jurors would have to agree together, one way or the other, whether you're guilty or not guilty. Do you understand that?
Yes, Your Honor.
Do you understand by pleading guilty you're giving up your right to have a trial?
Yes, Your Honor.
Now, if we had a trial, the prosecutor would be representing the state of Ohio, and she would have what we refer to as the burden of proof. With her having the burden of proof, what that actually means is that it's her job, or she bears the responsibility or the obligation to prove you guilty at a trial before you could ever be found guilty. You are presumed innocent of the charges, and the presumption of innocence sticks with you and stays with you until the state, if at all, was ever able at a trial to overcome that presumption of innocence and prove you guilty at a trial. Do you understand that?
Yes, Your Honor.
Now, you'd also have the right to have an attorney represent you at that trial, and if you could not afford an attorney, the courts would appoint one for you free of charge to do that. Do you understand that?
Yes, Your Honor.
Now, when I talk about that burden of proof being on the state of Ohio, since this is a criminal case, the burden of proof is what we refer to as proof beyond a reasonable doubt, which is the highest burden of proof there is in our justice system. What that actually means, it's the amount of the evidence and the quality of the evidence the state would have to present at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or each part of the criminal charges beyond any reasonable doubt before you could ever be found guilty at a trial of any of these charges. Do you understand that?
Yes, Your Honor.
You understand by pleading guilty, you are giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt?
Yes, Your Honor.
Now, in order for the prosecutor to try to do that, to prove you guilty at a trial, they would bring witnesses into the courtroom to testify for the state, and they'd answer questions from the prosecutor. Once those witnesses answered the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same person's questions, and we call that cross-examination. So she could ask them anything she wanted to, within certain rules. Do you understand that?
Yes, Your Honor.
Do you understand by pleading guilty you're giving up your right to cross-examine or confront these witnesses that would come in here and testify against you?
Yes, Your Honor.
Now, you'd also have the right at a trial, you can call your own witnesses to come to court to testify for you if you wanted to, and to answer your lawyer's questions. Now, you don't have to do that, and you're not required to do that, but you have a right to do that if you wanted. Do you understand that?
Yes, Your Honor.
And you further can request the court issue an order, and we call that order a subpoena. And what a subpoena would do is it would force or make someone come to court and testify for you and answer your lawyer's questions if they weren't willing to come in voluntarily on their own. Do you understand that?
Yes, Your Honor.
Do you realize you're giving up that right?
Yes, Your Honor.
Now, you'd also have the right at a trial. You could choose to testify on your own behalf if you wanted to. But you also have a constitutional right not to testify if you don't want to. That's a decision. That's a choice that you would have to make. Do you understand that?
Yes, Your Honor.
And since that would solely be your choice, what that really means then is that nobody else can force you or make you. Nobody could compel you to testify against yourself at trial if you didn't want to. I can't make you testify. But most importantly, the prosecutor, she would not be allowed to call you as a witness at your trial and make you get up on the stand and answer questions and testify. Your own lawyer can't make you testify if you didn't want to. Do you understand that?
Yes, Your Honor.
You further understand that if we did go to trial and you were found guilty, you would have the right to appeal or challenge that guilty finding to a higher court, a court that sits above me and reviews my decisions. By pleading guilty here today, you are giving up or waiving any right you have to appeal a guilty finding. This court will enter if your plea is accepted, as well as any other issues you could have raised or brought to my attention up to this time. You understand that?
Yes, Your Honor.
All right, well, do you have any questions at all about these rights we've just discussed? These are all the rights you have and all the rights you're giving up by pleading guilty. Any questions?
No, Your Honor.
Do you understand them all?
Yes, I do.
Do you still want to plead guilty?
Yes, Your Honor.
Do you understand a guilty plea is a complete admission of guilt? It means you're admitting to the facts being alleged by the prosecutor. We're not going to argue that you didn't do it or it's someone else's fault or anything like that. Do you understand that?
Yes, Your Honor.
Further, as a result of pleading guilty, the effect of that plea is that you'll be found guilty by the court, and then you will subsequently, on another day, be sentenced by the court. Do you understand that?
Yes, Your Honor.
Now, as far as sentencing goes, you're pleading guilty to a felony of the fourth degree. This felony of the fourth degree carries with it a possible term in prison of a minimum of 6 months, a maximum of 18 months, or any whole number in that range of 6 to 18. Do you understand that?
Yes, Your Honor.
Now, are you currently on probation or post-release control or any supervision to any other courts or agencies?
No, Your Honor.
Do you have any other charges pending against you anymore?
No.
If a prison sentence were imposed at any point in this case, upon your release from prison, you could be placed on what's called post-release control, sometimes referred to as parole. That's a period of supervision you would be on after you completed whatever the prison sentence was. And in this particular case, it could be up to 2 years. Do you understand that?
Yes, Your Honor.
And if you were on post-release control and ever violated any of the conditions of your supervision, we would have a hearing to see if you were what's called a probation violator. If it was determined that you were, I could extend your probation up to 5 years if it wasn't originally 5 years. I could impose more restrictive sanctions against you, or I could terminate your probation and send you to prison. If I did that, it could be, again, anywhere between 6 to 18 months. Do you understand that?
Yes, Your Honor.
Lastly, when we do come back here for sentencing, you'll have the right on that day to say anything you want. Anything you'd like me to know or consider. Your lawyer could speak on your behalf. She can recommend the sentence to the court. The prosecutor can also recommend the sentence to the court. Do you understand that?
Yes, Your Honor.
Do you understand that whatever the lawyers say at sentencing regarding what they think the sentence should be, it is just what it says. It's a recommendation. I don't have to follow that if I don't think that's the right thing to do. Do you understand that?
Yes, Your Honor.
All right, well, do you have any questions at all about the potential penalties you face by pleading guilty?
No, Your
You
Honor.
understand all the possible consequences?
Yes, Your Honor.
Do you still want to plead guilty?
Yes, Your Honor.
Have you had enough time in this case to talk about the matter with your lawyer and have her go over the reports with you, discuss the issues, and answer whatever questions you may have?
Yes, Your Honor.
Are you satisfied with the advice and counsel of your lawyer?
Yes, Your Honor.
Has she or has anyone made any promises to you about what's going to happen at sentencing which is inducing you to plead guilty here?
No, Your Honor.
Have you been threatened or coerced by anybody to enter your guilty plea?
No, Your Honor.
Are you entering your plea freely and voluntarily?
Voluntary, Your Honor.
Nobody's threatening you or coercing you?
No, Your Honor.
Okay. This is what you want to do?
Yes, Your Honor.
All right, what's going to happen at this point then is that prosecutor here is going to explain for me what she believes the evidence would show if we had a trial. I want you to listen to her because I'm going to have some questions for you about that, all right?
Okay.
All right. Ms. Hunter?
Thank you, Your Honor. If this matter would have proceeded to trial, facts would have shown that on September 2nd of 2024, a vehicle that the defendant was operating was pulled over for a traffic violation. During a lawful search of the vehicle, a loaded firearm was found in the glove box that was sent to the Lake County Crime Lab, determined to be operable. The defendant also did give a voluntary DNA swab. It was compared to the swab taken from the firearm, and the presence of his DNA was found on the firearm. He is not a qualifying adult based on a prior aggravated assault felony conviction.
Thank you. So, Mr. Powell, were you able to hear what the prosecutor just had to say regarding what she believes the evidence would show if we did have a trial?
Yes, Your Honor.
And what, if anything, do you have to say about those facts as she just presented them? Are they true? Did you do what she said?
Yes, Your Honor.
Very well, then regarding count 2, charging you with improperly handling firearms in a motor vehicle, a felony of the 4th degree with the forfeiture specification, what is your plea to that at this time? You can still be seated. I appreciate that, Ms. Robert. I know it's maybe different, but we just stay seated. So what is your plea at this time?
Guilty, Your Honor.
Thank you. I have in my possession at this point, Mr. Powell, a 4-page document called a written plea of guilty and judgment entry, which explains everything I've just explained to you. Before I can accept your plea, I need to make sure you understand this document and that you sign it here in open court. Now, my understanding is, before you came out here, you had a chance to go over this document with your lawyer. Is that correct?
Yes, Your Honor.
Ms. Robertson, is that accurate? Did you review this with Mr. Powell, read it over with him, answer his questions?
It is, Your Honor.
And did he indicate an understanding of it to you when you did that?
He did.
Is that correct, Mr. Powell?
Yes, Your Honor.
So you understand the document and what it says?
Yes, Your Honor.
You have any questions for me about what it says?
No, Your Honor.
Now, it also appears that you signed this document on the bottom of the 3rd page. Did you, in fact, sign it?
Yes, Your Honor.
Ms. Robertson, did you witness that?
I did, Your Honor.
Ms. Contour, you as well?
I did, Your Honor.
Very well, then, at this time, the court will accept the defendant's oral and written plea of guilty. Let the record reflect the defendant was here in open court with his lawyer, advised of all his constitutional rights, made a knowing, intelligent, and voluntary waiver of those rights. Court also finds the defendant understands the nature of the charge, the effect of the guilty plea, as well as the maximum penalty that can be imposed. Finding all this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea. Find the defendant guilty of count 2, improperly handling firearms in a motor vehicle, of felony in the 4th degree, in violation of 2923.16b with the forfeiture specification. Counts 1 and 3 will get dismissed as agreed upon at sentencing, but sentencing will be deferred. I'm going to order a pre-sentence report and investigation. Any other evaluations? Is there any issues with drugs or alcohol that you want to explore?
None whatsoever, Your Honor.
So we'll do just a pre-sentence report and investigation, continued bond. I have $15,000 cash surety or 10%. So what all this means, Mr. Powell, as far as bond goes, I'm continuing your bonds. There's nothing more you need to do about that except to continue complying with the conditions. One of those conditions is that you don't use any drugs while you're on bond. You have to submit urine screens if requested. They have to be negative. Positive screen would mean a warrant will be issued and your bond will be revoked. Do you understand that?
Yes, Your Honor.
Okay. So the purpose of this report I've ordered so I could learn more about you before sentencing, the way probation gets the information they need to complete the report, is they're going to conduct an interview with you. It's important that when you meet with them that you're open and honest with them, that you show up when you're supposed to for that interview. Because if you don't show up, then they can't complete a report. Without a report, I can't even consider probation as an option. If you're not open and honest with them, they're going to find that out, and they're going to let me know that, and I would obviously consider that sentencing. You understand that?
Yes, Your Honor.
So you're going to leave here now. You're going to go right over to the probation department. Do you know where that is, or do you know where that is? It's the, I don't know, where'd you park, in the back or in the front?
In the back.
Okay. It's right on that street there. It's the sheriff's department there.
Okay.
It's the 3rd floor of the sheriff's department. When you go in, you go to the right, and there's some elevators there. Take it up to the 3rd floor. To the left is the jail, to the right's like the offices, and that's where you're going to go. To the right, take the elevator up to the 3rd floor. They'll have paperwork there. They'll know you're coming. You go over there now just to fill out some initial paperwork and get your date to come back. So make sure you go there when you leave here.
Okay.
All right?
Yes, Your Honor.
All right. Ms. Conter, anything else for the record at this point?
Nothing further, Your Honor.
Ms. Robertson?
No, Your
Anything
Honor.
else? All right. Thank you.
Thank you.
Now we are present in case 22 CR 866, State of Ohio versus Anthony Robinson. Excuse me. We're here for a final hearing on a motion to terminate community control sanctions. Defendant previously waived probable cause, and as I said, we're here for the final hearing. Defendant's in court. 1 second.
Excuse me, Your Honor, I didn't hear you. Did you?
No. I said, hang on a second. I was looking up something. I'm sorry. My bad. All right, as I said, defendant's here in open court, and he's with his counsel, Ms. Nicole Novotny. Ms. Novotny, what is the defendant's intention at this time regarding the hearing, final hearing?
Yes, Your Honor. Good morning.
Good morning.
With regard to the final hearing, Your Honor, my client plans to waive and admit to the violation today.
Thank you. Mr. Robinson, you have been charged with violating the conditions of your community control sanctions. Specifically, it's alleged you violated Rule 8, which prohibits you from using, possessing, or having under your control any controlled substance not prescribed to you by a licensed physician. It's alleged that on February 18th of this year, you submitted a urine screen that tested positive for amphetamines, methamphetamines, and MDMA. Now, you have the right to have a final hearing regarding this allegation, which is a hearing where the state of Ohio will be required to prove the actual merits of what they're alleging. You could have that hearing, but you can also waive the hearing and plead guilty to the violation. Attorney's indicated she believes that's what you want to do. Is that correct?
Yes, sir.
Before I can accept your waiver and your plea, I need to make sure you understand the potential penalties you face if you are found to have violated your community control sanctions. If in fact that did occur, the court could extend your probation up to 5 years. It was originally 2 years, and then the last probation violation I extended it 6 months, so I could extend it another 2.5 years.
Yes,
I can impose more restrictive sanctions against you, including an order that you serve more time in our county jail, or I could terminate your probation and send you to prison. If I did that, I can send you to prison from anywhere between 6 to 30 months in prison. Do you understand the potential penalties you face if you're found to have violated your community control sanctions?
yes, sir, I do.
Well, having been so advised, what do you want to do at this time? Do you want to have the final hearing, or do you want to waive the hearing and plead guilty to the violation?
I'd like to waive it.
Very well, then as to the allegation that you violated Rule 8 by using and testing positive for amphetamines, methamphetamines, and MDMA, what is your plea to that?
Guilty.
I'm sorry?
Guilty, sir?
The court will accept your plea of guilty, find that you did violate your community control sanctions. Ms. Novotny, any reason not to go forward with sentencing?
Your Honor, I may proceed with sentencing.
Anything you'd like to say on behalf of your client?
Yes, Your Honor. Ultimately, we would like the court to consider to continue Anthony on community control with regard to this matter. We would like the court consider sending him to Lake Geauga Recovery, with Lake House being the option. I know he previously did Concord Pines. We've been in touch with a representative from Lake Geauga Recovery, and that would be ultimately, if the court were to send him, that would be ultimately the place that they would place him. Ultimately, for this reason, Your Honor, he was struggling financially with regard to after going to treatment, he was struggling. He was working with Culotta Landscaping. It wasn't his busy season, unfortunately. He was working with them, but again, struggling financially, struggling to find stable housing with that respect. He's trying to get his life all together, and it's caused a relapse. He does admit to the relapse, Your Honor. He doesn't deny that. He was compliant. He turned himself in to the jail with regard to when he was informed of the positive screen. He wants to get to the root cause of why this relapse. He doesn't want to continue with the continuous relapse that's occurring. He wants to maintain his sobriety, Your Honor. Prior to even working with Culotta Landscaping, he did work prior to 23 years with the UPS. He does want to continue. He does have a 19-year-old daughter that he wants to be more involved with her life, but he knows he has to maintain his sobriety and get to the root of this cause and why he is relapsing. He just wants to get that chance and maintain that. He is diagnosed with ADHD and PTSD. He goes to Signature Health for medication compliance, and he's prescribed Vyvanse, Your Honor. We're just asking for any type of leniency in the court to consider community control and potentially considering treatment for him, as he does want to get to the root of this cause and maintain sobriety and continuing on.
Mr. Robinson, you have the right to address the court before your sentence. You can say anything you want. Is there anything you want to say?
I would just like to take this moment and, apologize to you, Your Honor, and to the court, and to Jennifer Canals, who was my PO at Lake County Adult Probation. I suffer from this disease. I did not, wake up one day and just ask to be an alcoholic at all whatsoever. And like is my counsel has shared that, I just want to get to the root cause of it. And, I get these year and 6 months sober. I had a year and 3 months sober. And, I have an alcoholic mind. And the one thing that I have to realize is that with or without the alcohol.
This has nothing to do with alcohol, this PV.
I understand. But with or without it's a form of alcohol. Any other type of mood or mind-altering substance. I mean, my alcoholic mind will take me to a place that I shouldn't go to. And it was a mistake, and I just want to get to the root cause of it and try to get through my addiction and get help for my addiction.
Anything else you'd like to say?
Oh, no, sir, that would be about it.
Ms. Novotny, anything else?
Nothing further, Your Honor.
Well, this court has reviewed the original pre-sentence report and investigation. I've considered the facts and circumstances of the original underlying offense, the nature of that offense. I've considered the defendant's performance on probation. Consider everything that's been said here today. All this is considered by the court in light of the purposes and principles of felony sentencing set forth in 29-2911. As for the factors in 29-2912, I'll incorporate all the findings I made regarding the seriousness factors and the recidivism factors. The additional finding today that the defendant has again failed to comply with the previously imposed sanctions ordered by this court. This is now his second probation violation in this case. Being asked by the defendant to consider treatment and get to the root of the cause, I've given him that opportunity. He came in here for sentencing back in April of 23 where he had a criminal history going back 30 years. Had probation violations in the past. This was the 6th OVI. Despite all that, I gave him a chance at treatment. JTP program, the Ned Keating. He violated. And we came back here and he basically said the same thing. We wanted to consider treatment, continue with trying to find out the root cause of this. And I gave him treatment. I gave him everything we had. We had NeoCap, went to Lake Geauga, Concord Pines, aftercare. Got done with aftercare in January of 25. And then within, I don't know what, less than a month, he's violating again. There's nothing more I have to offer. We've given you everything we have. Sending you to Lake House is the same thing as Concord Pines. It's the same exact program. We just have two different facilities, the same program with different names. I just did that. You just got done with their aftercare program in January. I've given you every opportunity to do this. And there's no way this court can make a finding at this point that you are amenable to community control sanctions. You're clearly not. Therefore, it will be the sentence of this court that the defendant's community control sanctions be terminated. He'll be sentenced to serve a term in prison of 18 months. He has credit for 200. Is it 67 or 68? 268 days of credit. In this case, there has, I don't know what else you've done to the treatment, but I've ordered a lot. I've ordered restitution to be paid, and there hasn't been a dime of that paid in 2 years. Also, but 18 months in prison, 268 days credit. Need to advise you upon your release from prison, you could be placed on post-release control for up to 2 years. If you are and you violate any of those conditions, the parole authority can return you to prison as punishment for violating their rules for another 9 months, the maximum being 50% of the term I just imposed. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence. At this time, the court disapproves of the defendant's placement in a program of shock incarceration, intensive prison program, or transfer to transitional control. Defendant's order the penalty costs. Is there anything else for the record, Ms. Novotny?
No, Your Honor.
All rise.
Your Honor. We're here this morning in the State of Ohio versus Paige Taylor, case number 25 CR 117. The defendant is present in open court with her attorney, Mr. Watson. We were last before you on February 26th of this year. At that time, the defendant did enter a plea by way of information to aggravated possession of drugs, a felony of the 5th degree with the attached forfeiture specification. Your Honor ordered a pre-sentence report and a drug and alcohol evaluation, which have been completed. There will be a joint recommendation between the parties today at sentencing for community control sanctions. The defendant has 11 days of jail time credit.
Mr. Watson, any reason not to go forward with sentencing?
No, Your Honor.
Anything you'd like to say on behalf of your client?
Thank you, Your Honor. May it please the court. I'll be brief. Ms. Taylor, as the court is well aware, has a bit of a history with drugs and getting into trouble. This is her first felony level offense, but she does have a prior history with a lot of misdemeanors. She is currently serving a 120-day sentence out of Paynesville Municipal Court based upon those misdemeanor offenses. And she's here today with her hat in hand, Your Honor. I know she's been given opportunities in the past with other courts, specifically with treatment programs, and obviously she keeps getting in trouble. She knows she has a severe drug problem. She also, I might add, Your Honor, has some mental health issues. I think, Your Honor, if the court will consider a community control sanction specifically with treatment that would deal with her drug addiction as well as some mental health issues, I think she'd be able to get on the right track. She's the mother of 3 children. Currently, she does not have custody of any of them. She's informed me that she wants to sober up, she wants to straighten out, she wants to be there for her kids, she wants to be a mother. Her mother is in the courtroom today, Your Honor. She was here at the change of plea. I've been in contact with my client's mom throughout. She's very supportive of her daughter, obviously very frustrated and disappointed that she's in court yet again for a drug offense, but as any mother would be for their children, she still loves her and wants the best for her. My client, you're going to hear from her in just a minute, Your Honor. She's exacerbated with herself. She's tired of getting into trouble, of using drugs, of not being there for her kids, of going to jail. She wants to turn her life around. I'm hoping the court will consider a community control sanction in this case. I know we've supplied the court with an option for a treatment facility. I know probation's made their own recommendation, and quite frankly, Your Honor, if the court will consider any one of them, I think it'll be beneficial for her. So I'm respectfully asking the court to consider community control with an available treatment option. Thank you, Your Honor.
Ms. Taylor, you have the right to address the court before your sentence. You can say anything you want. Is there anything you want to say at this time?
I need help. Yeah, I'm sorry.
I can't hear you.
And I've been through a lot the last couple of years. I'm sorry I got in trouble again. I'm not trying to hurt anyone. I have a lot. I deal with a lot, And I'm sorry. I need the help. If you would be willing to give it to me. I want to try.
What's going to be different? I'm looking at your treatment history in the last 2 years. I've never seen anyone with as much treatment as you've gotten in the last 2 years.
I've finished a lot of places.
Well, then it doesn't work. Because you don't do it, you're not doing anything with it, apparently.
I wasn't doing it for me.
You weren't doing what for you?
I wasn't going to treatment for me.
Who are you going for?
My kids, spouse.
Well, your kids.
My mom.
Your kids wouldn't make you do this for the right reasons? Your kids wouldn't get you straightened out? I would think if I did something for my kids, it would be more important to me than if I did it for myself, to be quite frankly, frank with you.
In the beginning, you'd think that the love would be strong enough, but I found out that it's not. You got to do it for you. Have to need it for you. I'm tired of living this way. It's very exhausting. This last time out was very scary. I'm not gonna lie to you. probably the worst thing I've ever dealt with. I can't do it like that again. I just want to try, if you'll let me. It's, I know I've done a lot of rehabs before, but I'm like, I really put my all in this, you know?
You really put you were gonna put your all in it this time?
Not that I haven't before, but
Why am I supposed to believe that? What is there in front of me to make me believe that? And you were in treatment just in July and you walked out after 2 weeks.
Actually, I did not walk out. I went and I liked it and I had a good time. It was I think it was like almost 9 to 14 days. They kept me as long as they could, but I was on a grant and my insurance did not cover for me to go to residential. So I didn't walk out. I was kicked out.
That was the Everett House?
Oh, that was New Day. New Day was
I'm talking about Everett House. When you were there in July of 24 and the defendant reported that she spent 2 weeks in treatment before leaving.
I was upset.
Sorry?
Yeah, it's true. I was dealing with some things.
What were you dealing with? What are the things you're dealing with? Because you haven't worked in 2 years, right? Last time you worked was at Bob Evans in 2022. Which brings me to another question, quite frankly. How have you been buying your drugs? You said you've purchased any drugs at this point, anything you get your hand on that you can buy, you buy. How do you do it, even if you haven't worked in 2 years?
People give me money.
I can't hear you.
I beg for money. I ask people for money and get money.
Who?
My mom, my stepdad, it was not good. It was all bad. It was not good. I wasn't doing good out there. I'm not going to lie to you.
But if you're doing drugs daily, buying them daily, how can you get that much? How can you get money to do it?
You figure it out as you go.
So you have the ability to get things done if you need to. Just not putting effort in the right direction.
I'm really smart.
You figure things out if you need to. Well, you need to figure things out, but you don't want to figure it out for the right reasons. You're figuring them out for the right reasons. If you put the effort that you've put forth in getting your drugs and getting the money you need to get the drugs into the right things, maybe things could happen. But
I've been doing some research.
Sorry?
Sir, I've been doing some research on mental health while I've been in jail. I've been putting forth the effort since I've been there. I've been researching how the brain works and what chemicals cause it and what it can do to make me feel better naturally, and what diet changes and how emotions and stuff happen in different parts of the brain.
How about separating yourself from the people that have been bad influences on you over all these years? Been doing that? No. You think you hanging out and contacting and communicating with Mr. Shamblin is going to make you get back on the right track?
No.
But you're doing it.
I have codependency issues, yes.
Sorry?
I have codependency problems, yes.
Well,
I'm aware. What other people do with their life is not, right now I'm in a place where I have nobody and I have nothing, you know. If I go up to do rehabs and whatever it is that I'm going to do, I'm going to separate myself from people that are using, if they're using. But if
you need to worry about just yourself. You don't even need to worry about your kids at this point. You need to focus on yourself. If you don't make yourself the priority and take care of yourself first, then nothing else is going to matter. I know you have your kids and you love them, you want to get them back, but that ain't happening if you don't address these issues yourself.
empty cup, yeah.
Sorry?
I said, you can't pour from an empty cup.
Well, but you need to divorce yourself from Mr. Shamblin and everyone else also. And you keeping communicating with him while you're in jail doesn't seem like that's something that you want to do.
He's the only one that's putting money on my books.
I don't care. That's not an excuse. You're coming up with excuses again for that reason. So once you're out and about, if he's the only one that's giving you money to get food, then it's going to be all right to hang out with him, and you're going to go right back down that rabbit hole.
I understand.
It seems like I'm going to be wasting my time here. Is that what I'm going to be doing?
No, Your Honor. sorry.
Why did you walk out of Everett House after 2 weeks in July? Did you know that? You knew that, right, Dave?
She told me that, yeah.
My stepdad came up there and had crack in his hand when I was outside, just dropping my stuff off. And I decided to use that day, and I got scared to go back. I thought I was going to get in trouble. I no longer have contact with him. It's a long story.
Was that someone, last name of Phillips or something like that?
Yes.
What's his name? Something Phillips.
Paul Phillips.
Anything else you want to say, Ms. Taylor?
Please give me a chance.
Mr. Watson, anything else?
No, Your Honor.
Ms. Conter for the State of Ohio.
Thank you, Your Honor. We would just ask you to adopt the joint recommendation at this time.
This court has reviewed the pre-sentence report investigation. Considered drug and alcohol evaluation. I've considered what's been said here in court. By Mr. Watson, the defendant, prosecutor's joint recommendation. All of this is considered in light of the purposes and principles of felony sentencing set forth in 2911 of the revised code. For the factors in 2912, nothing stands out factually about the case indicating it's any more or less serious than what normally constitutes the commission of this offense. As for recidivism factors, many of these are present, almost all of them. Defendant has a history of criminal convictions. Goes back 6 years now. She has not responded favorably in the past to previously imposed sanctions. She's been on probation multiple times and she's violated her probation repeatedly. So you weren't in front of those judges saying, please just give me a chance. I'm going to do it right. I need to focus on myself this time. That's not what you were telling those judges?
I didn't go to rehab. Most of those times were not pushed into me from rehab. I've done most of my sentencing and then let it go. Not that I.
Take your time. I'm just concerned that what I'm hearing from you today is the same thing that you've told all these other judges in the past couple of years.
I didn't want to go to rehab those times. I basically felt forced to. I wasn't trying to get help then. I wasn't doing it for me. I didn't want it. I've honestly been fighting rehab for the last, how long? How long have I been saying I don't want to go? I don't want to go. I'm sorry, excuse my language. I really want to go. I'm tired. If I don't go, I'm not going to survive out there. This isn't it. This is it. This is my last shot. I don't even have any idea how I was alive today.
Court further finds the defendant was on probation at the time she committed this offense. It's a drug abuse problem that relates to the offense, and she hasn't really been willing to do anything about it. And she even just said she goes to these treatment programs, but it's not for her. She's being told she's got to do it, or for wrong reasons. I mean, she's been, like I said, there's been multiple treatment attempts, programs. I haven't seen this many, I think, total, even let alone within 2 years.
I made it 13 months once.
When was that?
With when Alessio went.
Sorry?
When I was pregnant with Alessio, back when I was on probation with Menor Courts, I finished probation after.
In 21, maybe?
Yeah.
March of 21. Your next violation was until September of 23, so there's a gap there that you either weren't using or you didn't get caught.
I was breastfeeding my baby up until 9 months, and then I had a relapse. And things got really bad.
There are no factors indicating recidivism is less likely. Under 292913B1, the defendant was on probation at the time she committed this offense. That eliminates the presumption for probation and permits the court to impose a prison sentence without having to make any findings to justify that. Well, it may appear that prison wouldn't be consistent at this point, the purposes and principles of sentencing. I don't know how I could find defendants amenable to community control sanctions. She's been on probation multiple times and just always violates these treatment facilities. When she's completed treatment facilities, it obviously doesn't work.
What'd you do? Mental health court.
But I'll give you one chance, Ms. Taylor. But you got to realize this isn't going to be like what you've done before in the past. You're going to get violated. If you get violated, you're just going to come back in and say, just give me another chance. I want rehab. I need to focus on myself. This time I really want it for myself. I'm not going to buy all that. This is your shot. If you're really sincere as you sit here and say, this is the time, now is real, and you're doing it for yourself. You realize that now. You really want it. If you don't get it, you're going to die out there. If this is all sincere, not just a bunch of bullshit you're giving me because you know you need to say something in order to avoid going to Marysville, we'll find out. But if you come back here for violations because, and you throw the way I relapse, like that's just, okay, we relapse, we'll just start this over again. I understand relapse is a part of it, but you've relapsed and relapsed and relapsed and relapsed and relapsed, and at some point that's not a part of it. And you don't make good decisions, and there's nothing about some of the decisions in regards to, everybody comes in here, it's about persons, places, and things. I hear that all the time, and I'm not saying that's not necessarily true, but you're not abiding by that. You're hanging out with the people that are you're gonna go right down that rabbit hole again. So we'll see how sincere you are. But I don't want you coming into this and starting this probation thinking that, all right, I was able to convince them into this, and then if I screw up, I'm just going to be like the past and get all these other chances. That's not going to happen. This is your shot. We'll see how sincere you are. I'm going to put you on community control sanctions for a period of 2 years. I'm going to order that you serve 60 days in jail, which is to commence upon completion of the current sentence you're serving. So that sentence you're serving right now is a 120-day sentence, which started just January 28th, so you're about halfway through it. So you still have about 60, 65 days left to serve on that. Once that's over, then I'm sentencing you to 60 days. Now, my intention is not to keep you there for 60 days, but it's to have enough time for you to be able to get into a facility. Now, if for whatever reason, the rest of that Painesville sentence gets eliminated early or stopped early, then your 60-day sentence, in my case, will start up. But you're doing 60 days after you've completed that. Once you've started serving my sentence, I will allow you to be released from my sentence Once a bed becomes available at Everett House, you're going to enter Everett House and successfully complete that program. You're not walking out after 2 weeks. If you walk out, you're getting 12 months in Marysville. You understand that?
Yes, sir.
So once you start serving my sentence, whenever that is, you can start checking with Everett House. And once a bed's available, I'll allow you to be released from the jail to enter Everett House. Any remaining time on my sentence will be vacated at that point. You're to successfully complete the program at Everett House. Actually, make this 71 days of credit because she has 11 credit. I just want to make sure that all the records are straight. So 71 days of jail, 11 credit. But otherwise, the same thing applies. You're to successfully complete the program at Everett House and follow all their aftercare recommendations. Upon completion of aftercare, you are to reside in a sober living residence for at least 6 months. You can stay longer if you want, but you're going to reside in a sober living residence for at least 6 months. Further conditions, you're not to use any drugs or alcohol. Must submit random urine screens. They have to be negative. A positive screen will result in your probation being violated. You're to attend at least 3 AA meetings a week and have a sponsor. After you've gotten back on your feet, you're to obtain and maintain full-time employment or education. If you want to go to school, go to some type of training, get certificates in something. It seems like you're a pretty bright kid, and if you had 3.6 grade point average, you're either going to work, you're going to go to school, or some combination of the two part-time to keep yourself busy. That's part of the problem, is you get nothing but time on your hands if you haven't worked in 2 years. So you're doing that. I also want you to obtain a mental health evaluation, follow any recommendations for any type of counseling or treatment. I also want you to get a psychiatric assessment to see whether any medications would be beneficial. Follow whatever recommendations are made with that and take all medications as prescribed. You're to have one doctor and one dentist that could prescribe you medication. If you have a specialist, that's fine too. But probation needs to know who the doctors are that give you prescriptions. You can only get them from those doctors. One pharmacy where you get prescriptions filled, they need to know where that is. You need to sign any releases they need, so if they need to talk to any of these doctors, they can do that. You're going to have no contact with Craig Shamblin. If I find out you're having contact with him and do that texting over there or phone calls, they're going to know. And if I find out you've done that at all, you're going to 12 months in Marysville. You understand that?
Yes, sir.
You're also not to have any contact with Paul Phillips. Pay court costs and supervision fees. Mr. Tompkins, anything else I should be considering here?
I don't believe so, Your Honor.
Mr. Taylor, if you're willing to put in the effort, I'm willing to give you a shot here, and we'll see how sincere you are. Do you have any questions about the conditions here? These are all designed not to punish you. I'm not saying you can't have contact with Mr. Shamblin to punish you. This is because it's what's in your best interest, and if you're going to get back on the right path, that needs to be a part of this. And all these other conditions. None of these conditions are meant here to punish you. Quite frankly, even the jail is not meant to punish you, because I'm only giving you the minimum time you need to be able to get into a treatment center. So this is all designed to try to help you and do what you say you want to do for yourself. And we'll see if you're really sincere about it. But do you have any questions about anything we've just talked about?
No, sir, thank you.
I need to advise you, if you fail to comply with any of these conditions, any of the rules of probation, if you leave Ohio without permission from the court, or if you commit another offense while you're on probation, a motion to terminate your community control sanctions will be filed. If it's found that you violated, I could extend your probation technically up to 5 years. I can impose more restrictive sanctions against you, or I could terminate your probation and send you to prison. If I did that, it's 1 out of 5, right, Ms. Contour?
Correct.
It'll be 12 months in prison, so that's what's hanging over your head, you understand that?
Yes, sir.
And that'll be consecutive to any other prison sentence you may be serving at that time from any other case, or that you're being sentenced to from some new case. Ms. Conter, is there anything else for the record at this point?
Your Honor, if you would just address forfeiture and the bond.
Oh, the bond can be released, and any of the contraband and instrumentalities will be forfeited.
Thank you.
Mr. Watson, anything else?
Nothing further, Your
All
Honor.
right, thank you. Good luck.